One reason women are accusing men of sexual harassment in the press, rather than the courts, the legal system that's supposed to investigate, address, and prevent sexual harassment, has failed them for decades. That's the conclusion from a review of more than 1,000 job discrimination cases by two law professors, Sandra Sperino at the University of Cincinnati, and Suja Thomas at the University of Illinois. Sperino and Thomas set out to understand how judges view discrimination cases. Their results are summarized in their new book, Unequal: How American Courts Undermine Discrimination Law. Sexual harassment is illegal in all workplaces and in every state. It's a form of gender discrimination prohibited by the Civil Rights Act of 1964, and it's illegal whether the alleged perpetrator is a person's co-worker or supervisor. But Sperino and Thomas argue that federal court judges frequently dismiss sexual harassment cases that likely meet the requirements under the law. In the past 40 years, they say federal judges across the country, who are mostly men, have developed an extremely narrow interpretation of what sexual harassment is under the law, and which behaviors create a hostile work environment. Repeated groping, sexual propositions, and sexualized comments at work usually don't meet that high standard. It's shocking, said Sperino. You read about women being groped or rubbed against a lot at work, and judges don't think that creates a hostile work environment. The federal courts have repeatedly dismissed women's well-documented claims of sexual harassment at work, the same kinds of alleged actions that have surfaced in media reports in recent weeks. That helps explain why less than 2% of job discrimination lawsuits, a category that includes sexual harassment, make it to a jury, and why only about 4% end up awarding damages to victims. Many claims never make it to court. The roadblocks to getting justice start with an unusually complicated and strict process to file a complaint against an employer in the first place. Employees who think their employer has discriminated against them, including through sexual harassment, which is legally considered sex-based discrimination, have to start by filing a complaint with the U.S. Equal Employment Opportunity Commission, which enforces federal civil rights laws. Requiring people to go through an administrative agency before filing a lawsuit is highly unusual. In most civil cases, including personal injury or negligence claims, anyone can file a lawsuit in court at any time. Congress also placed a strict time frame on when employees can file job discrimination complaints with the EEOC, no later than 300 days after the alleged discrimination happened. Then the agency has 6 months to review the case before an employee can sue in court. Once the EEOC gives an employee a right to sue notice, they have 3 months to file a lawsuit. During the EEOC's review of the case, the Commission investigates and tries to resolve the dispute through mediation. About half the time, investigators are unable to determine if an employer engaged in sexual harassment, and the EEOC notifies workers that they can sue their employer in court. Sometimes the complaints are settled during this process, and sometimes the EEOC will sue the employer in the most serious cases. In 2016, for example, the EEOC received 6,758 sexual harassment claims, and resolved 23% of the cases in favor of employees, adding up to $40 million in relief for workers. In 54% of their investigations, EEOC staff was unable to gather enough evidence to determine if harassment occurred. In those cases, employees are given permission to sue in court. The details of these cases are never made public, unless an employee decides to sue in federal court. And their chances of any success in court are slim. When victims take their cases to court, the odds are against them even if a case gets to court, meaning that the employee wins. Through the 6-month EEOC review process and chooses to sue their employer, federal judges dismiss job discrimination claims at a much higher rate than other civil lawsuits. Only about 4 out of 100 job discrimination lawsuits that are unsettled or voluntarily dismissed end up providing any kind of relief for workers, according to Katie Iyer, a law professor at Rutgers. This is highly unusual in the world of federal litigation, exceeding the negative outcomes faced by other litigants in both scope and degree, she wrote in a 2011 Minnesota Law Review Journal article. In other words, the odds are stacked against victims of discrimination more than victims of medical malpractice or consumer fraud, for example. The high dismissal rates aren't for lack of evidence. When deciding whether to dismiss a case through summary judgment, a judge needs to determine if a reasonable person would consider the alleged actions to be a violation of the law. More often than not, judges,